probity in public life and the integrity of institutions. We've been filing PILs. We bring out a report called the Status of Policing in India report. I think many of you have seen, many of you have attended release of these reports. These are basically about citizens' trust in policing, citizens' satisfaction in policing, the working conditions of police personnel, things like policing in extraordinary circumstances in LWE affected regions, in policing during pandemic, etc., etc. We are also leading partners in bringing out what is called the India Justice Report, which has 5-6 partners across the country. So, but Common Cause is better known for PILs it files, and you know some of our PILs about citizens' right to die with dignity, like the ban on private business of blood, things like self-congratulatory advertisement given by politicians in power, gross misuse of public money. You know, we also work on electoral reforms. There was one petition in the 80s which was about political parties not filing their returns, their records, all their accounts needed to be audited, etc., etc. So all that was done as a response to a Common Cause petition. And you know the recent one, the electoral bonds. We were co-petitioners with ADR. So, I mean, I don't have to tell you much about it because it's in news. Well, we were also petitioners in 2G and coal, just in case you thought this is only about this government. So, and along with CPIL in this case. Common Cause also challenged the appointments of CBI directors, and you know that there were many petitions in succession. Our lawyer, Prashant Bhushanji, is here, and he fought those cases doggedly, as he did in electoral bonds case, which many of you would have seen. Well, and I must also introduce CJAR. CJAR works on, it's a campaign for judicial accountability and reforms, and it works in tandem with people's organizations. It takes up issues of environment, judiciary and environment, judiciary and RTI, judiciary and public policy, and a whole lot of other issues. Today's discussion is about these 3 laws. The experts will talk about it. Since we work on policing, and the latest report, the Status of Policing in India report by Common Cause, is on torture and violence, custodial violence by the police. So we were going through these laws, and we just came across one where we know that in case of custodial violence, they are not even listed by NCRB as cases of kind of murder by the police inside police stations. So there used to be a compulsory judicial inquiry in case of every death in custody. So now that has been changed to a compulsory magisterial inquiry, which means that an executive magistrate, an SDM, can do that inquiry. So I think the experts will know how will it affect everybody and us. So over to Anjali Bharadwaj, who will introduce the guests and moderate today's discussion. Thank you.
Thank you, Vipul, and very warm welcome to all of you. We are trying to decode the new criminal laws. August 2023, we all know that the government introduced 3 bills in the Lok Sabha to replace the 3 existing, the then 3 criminal laws. The Bharatiya Nyaya Sanhita bill was introduced to replace the IPC, Indian Penal Code. The Bharatiya Nagarik Suraksha Sanhita bill was introduced to replace the CRPC. The Bharatiya Sakshya bill was introduced to replace the Indian Evidence Act. And the purported reason was that to replace these laws, the existing laws, which basically safeguarded and bolstered British administration, and their focus was on punishment rather than delivery of justice. That is what the reasoning that was given. These bills had several problems. Many of us would have read about the problems in these 3 bills, and they were referred to the Parliamentary Standing Committee, which gave its recommendations. And the revised versions of these bills were then introduced in Parliament in December. And unfortunately, without much discussion or debate, because 142 members of Parliament were suspended, these bills sailed through Parliament and they have become law. They got the assent of the President, and we are now told that they will come into effect on the 1st of July, 2024, this year. Now, these laws now basically overhaul the country's criminal justice system and will have a very, very far-reaching impact on all our lives. And it's extremely important, we felt, that we discuss them, we understand them. There have been statements made by the Home Minister about these 3 laws. He has said that the initiative freed the 3 laws from the mentality and symbols of slavery. And he has hailed these 3 laws as doing away with the section of sedition. So sedition has been replaced by treason. And there are many other positives that the Home Minister has stated. I quote, he said that the laws provide for a scheme to protect witnesses. He said that they will bring erring public servants to book. They make police more accountable. They have various provisions which, for example, 0 FIR and EFIR, which will add to the convenience of the victims. They will provide and create a separate directorate of prosecution, which will help ensure timely justice, and speed up justice is something that he has emphasized. He's also said that they will modernize the criminal justice system and increase conviction rate. While these are the things that we've heard from the Home Minister in his various interviews and on the floor of the Parliament, we've also heard several concerns raised by experts. The bills have been criticized as being anti-democratic, and I think there are 4 or 5 concerns that we've seen repeatedly, which I hope that our panelists today will shed more light on and walk us through what we should expect from these bills. But one of the big concerns that has repeatedly come up is that the BNSS, the Bharatiya Nyaya Sanhita bill, will increase the scope of police custody. So essentially, it will allow police custody beyond the first 15 days of remand. Now, this is a huge problem, very big concern, because we know how there is custodial torture very often. We've heard of that in police custody. So this is one aspect which is really worrisome. The other is that the offense of terrorism, which was earlier basically included in the UAPA, which is a special law which has some safeguards, many would say very wafer-thin safeguards, but it had some safeguards. The offense of terrorism has also now been introduced in the BNS, which is the Bharatiya Nyaya Sanhita, which means that there are actually, as many have said, there are 2 barrels now through which the government can fire, and this will provide unguided power to the police to choose the statute under which to investigate and prosecute alleged cases of terrorism. And there are fears that since the UAPA has been used and widely perceived to be misused to target political opponents, dissenters, that this might actually open up yet another way of targeting. The problems that have been flagged include trials in absentia, so which are permitted for proclaimed offenders in spite of fair trial implications. Many vague and broadly worded offences remain in the laws, despite it going through the Parliamentary Standing Committee. These include terms like false and misleading information is an offence, and endangering the sovereignty, unity, integrity of India, very broad. very broadly framed. There are provisions related to handcuffing which have raised concerns, and there is insertion of a phrase of a common object in the definition of criminal conspiracy, which is also something concerning. So I think we have a stellar panel with us today. We couldn't have asked for a better set of people to enlighten us about these laws. And I'm going to first invite Professor Mohan Gopal. Professor Mohan Gopal was director of the National Judicial Academy from 2006 to 2011. During the period of 12 to 19, he was the founder chair of the National Court Management Systems Committee of the Supreme Court of India. He's also a former director of NLSIU, Bangalore, and he's known for his active work in reforming legal and judicial institutions. You're welcome, Professor Mohan Gopal, and the floor is yours. I request the speakers to speak for about 12 minutes. Towards the end, we'd like to open the floor for discussion.
Thank you very much, Anjali, for that very succinct introduction to the topic. I think we've all been very concerned about this bill for some time now. I've written, I think, at least 4 articles, number of videos. I've made many presentations on this in great detail. And not that it did not have any effect. I think it had a couple of effects. The first draft had a very open sky definition, a new definition of terrorism, supplementing the UAPA definition. So as a result of some of these early efforts, I think somehow when the second draft came up, we saw that that draft had been removed and replaced by almost the identical language in the UAPA, which is a known devil, with a very minor change. A couple of other things also which are not worth mentioning, but these were only sort of playing safe and responding, I think, to the concerns of their own constituency rather than anything we said. So we need to move forward. We now need to stop comparing the old and the new, because the new will be upon us in July. So we need to understand the nature of the threat and how we respond to it. I lay out my understanding of the threat, and I'm sure we have a very eminent defender in court of our rights in criminal law, Brinda Grover, who will take us to the new phase which we have to now start thinking about. And it's only when that happens that we will start to see the real flesh of this law, because ultimately it will be, the question will be, how will judges see it and how will they interpret it, how will we see it on behalf of those who are accused, and what arguments will we articulate to defend ourselves. But I'd like to just do 2 things. One is set a larger context very briefly, and then focus on the 3 areas that we now need to focus on. The larger context is, as I said, indicated earlier in that very nice session that Mr. Prashant Bhushan organized a couple of days ago. What we are looking at, the Supreme Court jurisprudence on civil rights, what we are seeing is actually a concentrated attack on Article 19. From all fronts, there's a really concentrated attack on Article 19, and in particular on 3 clauses of Article 19. 19(1)(a), which is speech and expression. 1(c), which is association and union. So all the attack on any kinds of effort to associate with each other and work together. And the third is assembly. So 1(a), 1(b), and 1(c) are under severe attack. And we all know that when 1901 was introduced, there were no reasonable restrictions on 1901, and they were introduced later during the early years of the Congress government by the First Amendment and then by the 15th Amendment. And now there are several restrictions, but even then they're very quite specific. So if we look at the restrictions that are applicable, then we'll find that the restrictions, basically the relevant restriction for us is to look at public order, the assertion of public order. There is morality and so on, but all these three, the common element between these three grounds is that we are being attacked on the grounds of public order, when actually we are fighting for order against an attempt to destroy order. We are fighting for the rule of law. We are fighting for the rights that will ensure there is peace and harmony in the society. But ironically, it is the attack against us that we are disrupting order. So the first challenge, I think, is to understand that we are here to defend Article 19, and particularly 1A, 1B, and 1C. And we need to become much more familiar with that. And we need to, I think, we need to sharpen our ability to use constitutional law to defend 19 and 19 in general, and 19(1)(a), B, and C in particular. That's a great challenge we face in the legal system. Now, that's the broad picture. We can discuss it later. The second point I want to make is that there are three areas of attack on which we need to really focus. Those are really the double-barreling phrase that I had used earlier, double-barreling of terrorism and organized crime. One barrel was bad enough, and now we have two barrels. And there is no order. We are supposed to be attacking order, but there is no order in how this is going to work. And a police officer at or above the rank of deputy superintendent of police is vested statutory power to decide under which statute, BNS or UAPA or both, will be charged, depending on whatever is convenient for them, and then convicted and punished. And we may be looking at US-style punishments running into decades, if not centuries. Now, as was indicated, I'd like to spend a couple of minutes going through those laws. And then we've also had this new petty organized crime, which is really targeted at the lower economically marginalized and social groups, because it's very easy to target them with the kind of ingredients of petty organized crime, and we'll briefly look at that. But the big one is 152. I would not dignify it with the word treason. I'd call it sedition plus, because it is a lie that sedition has been deleted. We still have sedition, and it's sedition plus. Yes, sedition plus treason, but not just treason. It's sedition plus treason. And basically, as the Home Minister has said, they've converted Raj-droh into Desh-droh. And Desh means, of course, we know what it is. It is the Hindu Rashtra. So whatever we are basically, seeing an effort to attack those who question their idea of nation. So before I get into the last part, which I'll go through some of these clauses, I want to say that ultimately what we are fighting here, I said this at the last seminar also, we must realize is a part of the struggle to convert India into Hindu Rashtra. That's where this is coming from. It's the idea of Hindu Rashtra that's attacking us. Now, all these years when terrible brutality took place under this criminal justice system, by the police, by the jails, in the courts, we could all say that this is a colonial legacy, blame the British colonialists who were responsible for it. But now we have a certificate from the Prime Minister and the Home Minister that this law has been cleansed of all colonialism. This is pure Bharatiya Nyay. This is pure Hindu Nyay. So any brutality that now occurs from July 1 onwards, we know is Bharatiya brutality and Bharatiya Nyay. So at least now we don't have any excuse for that it is a colonialist or visiting this brutality on us. So we must remember that this is an integral part of our struggle against protecting the democratic, secular, socialist republic against the establishment of a theocracy in the form of a so-called Hindu Rashtra. And for that, unless we are ideologically and politically able to combat that, there's very limited scope for us to defend it at the other end of the pipe, which is where we stand in courts, trying to get bail or acquittal for the convicted. Having said that, I'd just like to read together. Preliminary, we need to understand this how we will understand it, how judges will understand it, how the government prosecutors will understand it and apply it. But let's remind ourselves of the plain language of the three provisions that we are up against. So section 152 says, whoever purposely or knowingly, by words either spoken or written, or by signs of, that's why I said it's sedition plus, it's the same language, or by visible representation, or by electronic communication, or by use of financial means or otherwise, excites. So please don't get excited, because I may be prosecuted. Excited or attempts to excite secession, whatever that means, or armed rebellion, we can rule that out, or subversive activities. The kind of activities we are now engaged in right now, according to the government, or encourages feelings of separatist activities or endangers sovereignty or unity and integrity of India, or indulges in or commits any such act, shall be punished with imprisonment for life, or with imprisonment which may extend to 7 years, and shall also be liable to fine. Right. So this is what we're looking at. If we are accused of subversive activities, and we are convicted for subversive activities, and this could well be characterized as a subversive activity, we're looking at imprisonment for life, no less. Then let's look at 302, which is not new, but still now it doesn't matter whether it's new or old. We're looking at the instruments that will be used against us. Whether it was in the old IPC or not is no longer relevant. So let's look briefly at 302 of BNS. 302 says, whoever with deliberate intention of wounding the religious feelings of any person utters any word or makes any sound in the hearing of that person, or makes any gesture in the sight of that person, or places any object in the sight of that person, shall be punished with imprisonment of either term, which may extend to 1 year, or fine, or with both, right? So wounding the religious feelings of another person. Then we have the full panoply still of all the provisions on causing divisions, disunity between communities and groups. All of those are still in place, unchanged, which have been misused, 153, 153A, except 153AA, which has been deleted. 153AA, which was never notified, thanks to the influence of Nagpur and Delhi, 153AA said that the use of organizing mass drills carrying weapons, including lathis, in public is a crime. That has been deleted from the Bharatiya Nyaya Sanhita, which means that Bharatiya Nyaya is exhorting us to have mass drills carrying arms on the street. So this is so we have these, plus I'm not going through the familiar 153 series of provisions, which we are all, I think Ms. Grover has been fighting for years in court, and we are all familiar with it. But let's come back very quickly to 110 and 111. 111 is organized crime, and 112 is petty organized crime. Again, organized crime is any very open-ended, any continuing unlawful activity, including. So then you can disregard anything else. It's any continuing unlawful activity, and any continuing unlawful activity means an activity prohibited by law, which is a cognizable offence punishable with imprisonment of 3 years or more, undertaken by any person as a member of an organized crime syndicate or on behalf of such syndicate, in respect of which more than one charge sheet has been filed before a competent court. So all you need is a charge sheet should be filed. There is no need for conviction. Charge sheet is filed, and then you can be accused of being working with an organized group, and you can be charged with organized crime. Of course, needless to say, whoever commits organized crime shall, this is standard now, if such offence has resulted in the death of any person, be punished with death or imprisonment for life, and in any other case be punished with imprisonment which shall not be less than 5 years, but which may extend to imprisonment for life, even if no one is killed, and shall also be liable to fine, which shall not be less than 5 lakhs of rupees. That is organized crime. And then there is petty organized crime, which is directed at the poor of the country. I don't like using that word, but I think that's what they are directed at. Whoever, being a member of a group or a gang, either singly or jointly, commits any act of theft, snatching, cheating, unauthorized selling of tickets, unauthorized betting or gambling, selling of public examination question papers, I don't know why that's got so much prominence, or any other similar criminal act, is said to commit petty organized crime. Now they have expanded the definition of theft from the earlier penal code, or the earlier other parts of this penal code. For the purposes of this subsection, theft includes click theft, theft from vehicle, dwelling house or business premises, cargo theft, pickpocketing, theft through card skimming, shoplifting, and theft of ATMs. Whoever commits any petty organized crime shall be punished with imprisonment, which shall not be less than 1 year, but which may extend to 7 years, and shall also be liable to fine. This is the main attack. Then there are very many other small things, such as they've introduced, we always had a law saying you have to obey public officials, but subject to various constraints. Now there is a provision saying that you have to obey any lawful direction of any police officer. If you don't, if the police officer says you are not obeying his lawful order, he can detain you for 24 hours on the spot. And so imagine what that will do for people, for marginalized sections on the ground. So, and there are other provisions. In terms of procedure, we know, and I think Anup will talk more about it, about police custody, the huge expansion of our stay in the torture chamber, has been extended from 15 days maximum to up to 90 days in specified cases. I'm sure Anup will talk about that. And we're also now, all of us are liable to be ordered to give our biometrics. Initially it was for those who are accused. Now whether you're accused or not, if it is related to a case that the magistrate feels is related to the case, we can be ordered to give our biometrics. There is no compulsion in certain cases to file an FIR. Reversing the Lalita Kumari directive, and they can do a preliminary inquiry and conclude that there's no need to file an FIR. It's already very, very difficult to file an FIR, as we all know. And of course, the icing on the cake is that handcuffing is back, and reversing the Krishnaiyer dicta. The other Krishnaiyer dicta that has been completely reversed is bail, not jail. So no handcuffing is also now, and it's encouraged. Shall handcuff. There's the two words there: shall handcuff in certain, or may handcuff in certain cases. And across the board, there's increased incarceration. And so the idea is to use. So I'll conclude here. What is going on here is criminal law was an instrument of dealing with the problem that humanity has faced since human beings existed: crime and punishment, right? How to define crime and how to punish. Even this colonial law largely dealt with that. But now we have a penal law which has nothing to do with crime and punishment. Introduced into it an element which is used simply to suppress dissent and opposition. No connection to crime, no connection to punishment, just dissent. And so we are seeing a completely new and unprecedented use of the criminal law, completely disconnected from the idea of crime and punishment. So frankly, these cases should be handled by constitutional lawyers. We'll have to invoke constitutional law in the...
Thank you, Professor Mohan Gopal. And I think what you've really laid out for us is a very frightening scenario in terms of a very, very clear and potent attack on Article 19, our ability to engage, to dissent, to voice any kind of criticism, to flag anything that we feel is a problem. I think, and what we've seen over the last many years now is that there's been a systematic shrinking of that space. And these kind of provisions which you talked about will further push back and cause a chilling effect, which I think is really very, very concerning in any democracy. Without further ado, I'm going to request our next speaker, Vrinda Grover. We all know Vrinda is a lawyer, researcher, women's rights activist, human rights activist. She has appeared in very prominent cases related to human rights, sexual violence, communal violence, police accountability. And currently, Vrinda is serving as a member of the UN's Independent International Commission of Inquiry on Ukraine. So, Vrinda, the floor is yours.
Thank you. I want to thank CJR for organizing this so that we continue to engage, and lawmaking is not the preserve of those who are in majority. It impacts all of us, and we will therefore have to discuss, debate, and engage with the issue. And while we may be held liable, I'm very sure the vicarious liability will go to CJR. So we are in good hands. And common cause. Oh, they're sitting together. That's very reassuring. Taking forward what, and there comes our other speaker, सारे उन्होंने सोचा पास ओवर लेंगे यहाँ पे आइए सारे. So taking forward what Professor Mohan Gopal set out the context for us. I remember K.G. Kanabaran in his book Wages of Impunity, and in many of his deliberations he always spoke about this journey of civil liberties being a journey from being a subject to a citizen which is a rights-bearing citizen under the Indian Constitution. Today, I think in that journey from subject to citizen, we have now moved to suspect and supplicant. So suspect, because if you look at the manner in which crimes are codified, and which Professor Mohan Gopal has given us an overview of, the citizen is suspect. It is the state which will, which has nothing to answer for and no scrutiny to be offered of the state, and supplicant because all that we can seek is benefits of PDS, rations, NREGA, etc., which keeps us at a subsistence level of existence. And that is the frame within which I would locate the amendments that have taken place. And we are not being seen as rights holders. And as Professor Mohan Gopal said, I would totally endorse this. This is now a regime to control, suppress, and contain the Indian citizenry as to how it will conduct itself both in private and public life. Particularly if there is any challenge, and the challenge can be even through an article, to any powers that the state may exercise. We've also seen a pushback, as was said. There are certain strides that were made through judicial, through judgments, through interpretation, whether in terms of D.K. Basu with all the rights of under trials, Arnesh Kumar, Sunil Batra, all these were in various ways expanding the scope of, and I would definitely want to foreground Article 21 of the Indian Constitution, which deals with personal liberty and right to life. And I think we need to constantly keep 19 and 21 as centered when we discuss. And I'm very glad that Professor Gopal drew our attention right at the beginning to constitutional roots of criminal law, because both in the teaching of criminal law and in the practice, it's seen as though criminal law has nothing to do with the Constitution. But of course, it can only draw, and particularly a law which has now been enacted and will come into force soon, which claims that it is breaking away from the colonial past. Therefore, it must meet the test of constitutionality. It can no longer say that it does not need to satisfy every aspect of Chapter 3, which is the Fundamental Rights chapter. I would like to begin with something that Vipul spoke about, one of the reports, and I've read their earlier reports of Common Cause on policing, and they're very, very important reflection of what is happening in society. On the aspect of torture. So, what are the silences today in the new laws? Torture was something that the colonial regime committed on, whether it was the cellular jail and Kala Pani and what was happening there. And in the 75th year, we have been talking about various freedom fighters. So torture is something that a colonial regime inflicts on its subjects to control and put fear in them. We also know, and we don't need any fact-finding reports, please open the earlier reports. I wouldn't comment on the current report of the NHRC. It's more in absentia than active. NHRC's own reports have annually recorded multiple cases of torture across the country. It's a different matter that they usually only talk of compensation and have only once asked for prosecution. But torture is a reality which is documented in the official records of the government. There is absolute silence in codifying it, although the Indian state has at the UN in 1977 signed the Convention Against Torture and said that we will enact a separate law, because that is a requirement under the Indian Constitution, to have your own domestic law before you ratify. It has said this since 2008 in each of the universal periodic reviews at the Human Rights Council in Geneva, as well as before the Supreme Court, and the Law Commission has spoken of it, and yet we find the offense of torture completely conspicuous by its absence. Now let us link that to two things here. One, Section 196 of BNSS, which is the Code of Criminal Procedure. In fact, it's very interesting. It's exactly what we've been hearing in a lot of the political rhetoric and political cacophony, where language has lost its meaning. And therefore, when it says Bharatiya Nagrik Suraksha Sahita, you can rest assured that it will have no Suraksha for the Nagrik in it. And that's precisely what the Code of Criminal Procedure sets out to do, because it's all about perception and about creating an image that we've used this language. The language is not held up by the provisions of the code. The Criminal Procedure Code, BNSS, has a very interesting provision. So torture, custodial torture, again, as I said, is a reality we are all familiar with. There was a shift made in 2005 in the law, and in the Code of Criminal Procedure, an amendment was made that if there is any person who dies, disappears, or is raped in police custody or police action, there will be a judicial magistrate inquiry. The judicial magistrate has been removed, and what has been brought back is the magistrate. Now, the magistrate can be your executive magistrate, can be your STM, can be your district magistrate. To expect a district magistrate or STM to actually conduct an inquiry which will probe and see whether the police has been responsible is not something that any of our experiences will verify. And it was precisely for this reason that in 2005, the law was amended. Let me give you two examples. In all extrajudicial killings, what is euphemistically called encounter in this country, it is mandatory to have a judicial magistrate inquiry as per the PUCL judgment, of which, if I'm not mistaken, Prashant had argued that matter in the Supreme Court. What this code is doing is actually, as was pointed out with respect to the Lalita Kumari mandatory registration of FIR, it is actually in defiance of Supreme Court verdicts. The PUCL judgment lays down guidelines and directions which are mandatory and which have the writ of law, that you will have a judicial magistrate inquire into any death by police action. In fact, in the famous, infamous, depending on how you want to look at it, in the Ishrat Jahan fake encounter case, the truth for the first time we got a glimpse of it when the judicial magistrate Tamang had written his report under what was then 176(1)A and is now 196. There was a death of a farmer in the Haryana police firing 2-3 days ago. There is a police action and a person is dead. The Haryana police has just, while I was sitting here, I saw they said he didn't die because of our bullet. So there is a controversy on facts. How is that to be resolved? It is a police action. Now, to ask the police to investigate is a complicated thing. If the law was to be adhered to, there should automatically be a judicial magistrate inquiry into the matter. This has removed that and brought it back to the magistrate. So we've actually moved into the colonial past rather than move forward. Link that to torture. Another aspect I'd like to link to torture is the expansion of duration, period within which police remand can be taken. And here Anup and I may have a different reading of the law. As I read the law, which is section 197, what does the law, let me just try and simplify this. The law says, and this has always been the law in this country, the police can take 15 days police remand after arrest within the first 15 days. If I'm arrested, you want police remand, you have to move an application to the concerned magistrate and give your reasons and say you want remand for 2 days, 5 days, 10 days, maximum of 15 days within the first 15 days. Once the first 15 days of arrest are over, the police cannot take a person under the ordinary law into police custody for purposes of investigation, recovery, whatever. That is the law presently. And that keeps a check on coercion, torture, etc. by the police. The new provision says you can take police remand for a total period even now of 15 days. However, that 15 days can stagger over, can be taken over a period of, if the offense is such that the charge sheet is to be filed in 60 days, then till the 40th day. If the offense is more grave and you have to file the charge sheet in 90 days in a murder case, then till the 60th day. Total period remains 15 days, but a person has been sent to judicial custody, he's in jail, and the police can say, okay, I want to ask one more question. And again, the person can be brought out. This is going to have 2-3 ramifications. One, the ability to coerce, torture, and the power of the police over the person arrested is going to amplify because it doesn't end in the first 15 days, it can continue. Secondly, how will you apply for bail? When you will apply for bail, you will be told the first thing the prosecutor and the IU are going to come and say in court, and they just move these applications. I mean, anything can be written in them. Nobody holds them, asks them any serious questions. They'll say, we still need to do custodial interrogation. On this aspect, our investigation is not complete. We are still examining this We are still looking at the CDR. We are looking through, because taking anybody's devices is completely routine. Whether they are required in the case or not is irrelevant. The first thing they do is phone de do, laptop de do, kuch aur bhi hai, wo bhi de do, and they have some huge place where they keep them. So they'll say we are examining, and custodial interrogation can go on in, say, a case which is of serious offense till 60 days. After, in 90 days, you still have to file the charge sheet. Your pre-charge bail is going to be stultified to the point of negation. Because what will the judge say? अभी तो चार्ज शीट फाइल होने ही वाली है, अब आप चार्ज पे ही बहस कर लेना. So what is this going to do to personal liberty actually? It is your entire prospect of pre-charge sheet filing bail and pre-framing of charge bail has actually been completely subverted by this. Because there is no IO which will come and say my investigation is complete. They will complete it only on the nth hour so that nobody can get benefit of the statutory bail of 60 days or 90 days, whatever be the offense. So to my mind, there are 2-3 very, very grave implications of Article 21 due to this staggering. And what is the rationale? There is I would really want to understand that what in our experience of the last so many years has told us that the first 15-day period is not good enough for police investigation. They need more time. Actually, if you see, the more time you will give them, the less rigorous the investigation will be. And anybody who wants to understand the rigor of investigation just needs to see a few charge sheets and will be quite surprised by what is going on. Another aspect I would again want to link to torture actually is about handcuffing, which again Professor Mohan Gopal referred to. What happens today? And I remember in the Parliament attack case also, they were not allowed to handcuff anybody. People were brought to Patiala House and they were taken. It may sound unreal today. This happened in this city, not too far gone. If you want to handcuff somebody, you have to move the police has to move an application to the court. The court has to be satisfied for the reasons. Today, who's going to decide? The cop. What is the cop going to do? What is the point of all those tomes of dignity, etc.? So the point of dignity is totally lost. I'm going to move very fast. Sedition has already been discussed. I totally agree with what has been said. And I think the language is so open-ended and vague that, it's about actually that argumentative Indian, as Amartya Sen famously called it, is to be silenced and is to be the suspect supplicant who should not speak. One other gap, and I want to refer to some of these things because I think they've not come much in conversation. Section 377 of the Indian Penal Code, which had criminalized consensual same-sex, was read down by Navtej Johar, has now been deleted. What does that do? If a trans man or a man, an adult man, is sexually assaulted, abused in any way, what is the protection in law today? POCSO covers boys and girls till 18. What is the protection for men? What is the protection for trans men? Trans men face a lot of very severe police and custodial sexual violence. On the one hand, there is a lot of hullabaloo that is made about how they are, trans persons are part of Indian heritage, and yet you are not giving any protection where it should have been provided. And the Transgender Act does not do the needful at all. It completely trivializes the offense. I want to point out one other aspect here, actually two, so you'll just give me 2 minutes more. There is there is usually a misunderstanding where everybody says, in India, women have a right to abortion. Women do not have a right to abortion in India. There is actually a completely colonial perspective which was there in the Indian Penal Code, has been retained in the Bharatiya Nyaya Sanhita, which says that even if a woman voluntarily tries to have a miscarriage, she will be penalized and punished with some 10 years, 7 years, whatever years. The Medical Termination of Pregnancy Act was created as an exception to these penal provisions, so that doctors and medical professionals were not penalized when enabling a woman. So yes, you can have a medical termination of pregnancy, you can have an abortion, you can go, but the doctor gets to decide. Women don't get to decide. If you voluntarily do it on your own, then you can be actually punished, and those provisions continue to be here. So when it comes to the control over women's sexuality, women's bodily autonomy, there is no movement taking place. And despite a huge advancement in our jurisprudence through Puttaswamy, etc., which have, and Navtej Johar, which have spoken about these things, we don't see that in the code. I also want to just mention here that the provision on having sexual intercourse by deceit or promise to marry without an intention to marry will now amount to a crime not amounting to rape is a provision that I would absolutely not agree to. You cannot, this is actually both, it's again treating women as not having agency and infantilizing women. So from patriarchy to paternalism is not going to be in the, it's not something that women have asked for or women are seeking. What was the shortest chapter of the Indian Penal Code? It was offences by the state. What is the shortest chapter of Bharatiya Nyaya Sanhita? It is offences by public servants. Many of us, including people like Harsha here, worked very hard to create a law which would take on the impunity of mob violence, particularly communal violence, as we understand it in India. Who is responsible for that? Forget the people are fighting. That the law knows how to deal with. What is the public servant doing at that time? What is the civil servant doing, the administrative authority doing? If this is a Bharatiya non-colonial law, it would create accountability to the citizen of the public servant and the civilian authority. It does not do so even for a minute. The entire purpose of centering Chapter 3 in the Constitution, and to my mind what decolonization means, is that the state will be accountable to the citizens. That is not what it does at all, and therefore that whole chapter of Chapter 12, which is from Section 196 to 201, does not create any accountability, despite there being a wealth of documentation as to what this does. I will end here because my time is over, but the overlap between MACOCA, Terrorist Act definition in IPC and in UAPA is identical. And to have two laws, some of the reasons have already been outlined. I would just highlight one more. When international scrutiny takes place, particularly at the United Nations, etc., counter-terrorism laws come in for stringent criticism, not the ordinary law of the land. So therefore, you're actually dodging certain kind of scrutiny by bringing it in here, and of course, enhancing arbitrariness completely. And therefore, and on sedition, Mohan Gopal has already spoken. In fact, it's very interesting if you look at the May 11th, 2022 order by which sedition was put in, all the trials, etc., were put in abeyance. The affidavit filed by the union quotes the Prime Minister, saying that the Prime Minister says that at this juncture of Amrit Kal, he is very cognizant of what is happening. And that's all, it's been reported. The then Chief Justice, Justice Ramanna, has actually recorded that whole thing in the order. So what we are seeing today is that not only are we no longer being treated as free citizens, but yes, I agree, this is the majoritarian, authoritarian state of which we will be suspect, and we have a host of other laws all the stuff that is happening in the digital space, and of course, all our biometrics that are being taken. And therefore, both the conversations, the debates, and the challenges to this by citizens will continue. Thank you.
Thank you, Vrinda. That was very, very lucid and very, very comprehensive. And one of the things that has been said by the Home Minister is that the new laws keep crimes against women and children, matters affecting the human body, security of the country's borders, etc. At first, it keeps it at the center of these laws, but I think we heard a very different analysis from Vrinda. And thank you, Vrinda, also for bringing our attention to Article 21. Professor Mohan Gopal talked about Article 19, but I think what we heard even the day before yesterday in the CJR discussions and seminar was how the issue of liberty is really not being upheld. Our right to liberty, fundamental right to liberty, is not being upheld in the manner that we would like by the courts. And through this provision of increasing the period in which police custody can be sought, I think you sort of really highlighted the concerns around liberty further. Thank you very much. I'm now going to request Professor Anup Surendranath. He teaches criminal law, constitutional law, and legal methods at NLU Delhi and is the executive director of Project 39A. It's a criminal justice program at the university. He holds the S.K. Malik Chair Professorship on Access to Justice and is also the advisory council of the Bonavero Institute of Human Rights at the University of Oxford. Anup has also spoken and written extensively on these laws. Professor Mohan Gopal, of course, has, and we heard from him, and so has Anup. So Anup, can I request you to please come here and share your thoughts with us.
Yeah, good evening, everyone, and thank you for having me here today. I'm going to do a bit of a deep dive into some of the provisions and try and give you a sense of my concerns. Vrinda already flagged that I have a different position on the police custody provisions, and I do think that what the new law does is expand possible police custody to a whole of 60 or 90 days, rather than saying that that the 15 days of custody can be taken anywhere in 60 or 90 days. The reading that I have of the new clause in the BNSS is that it actually expands possible custody in police, for police custody, to 60 or 90 days, because it omits a crucial clause, a set of words from the existing section 167(2), the proviso, which says, currently it says, a magistrate may authorize the detention of the accused otherwise than in the custody of police, right? The new law deletes those words, otherwise than in the custody of police, and then says that you can have a custody of up to 60 days or 90 days, depending on the offense, right? So for me, there is an expansion of potential police custody currently from total of 15 days to a total of 60 or 90 days, depending on what the offense is, and one could and this confusion or this disagreement is also a problem on something as crucial as this, right? That there is lack of clarity on this, and already we are seeing disagreement on this, and by the time this gets resolved in some authoritative fashion somewhere by the Supreme Court, you can imagine the kind of confusion that is going to be unleashed and the kind of liberty that is going to be at stake, even if we accept and acknowledge this disagreement, right? And to understand this, to understand what the enormity of what is being done, and if you were to see my reading of it, and even this is worse than the UAPA also, because under the UAPA, the total custody that's possible is 30 days, and then there is a procedure for extending that police custody. Here you're having a potential reading of the new law, which allows 60 or 90 days of police custody. The second aspect that I want to focus on is on bail provisions, right? Under the bail provisions in the BNSS, there is a massive shrinking that is about to happen, right? And I say that for the following reasons. Currently, as the law stands under 436A of the CRPC, if you have served half of your sentence without a conviction, you can be let out. The disqualification for this, that the only category of persons who are not eligible for this benefit are prisoners sentenced to death. Now, under this new law, this exception or this exclusion is broadened and saying even if you are sentenced to life imprisonment, you cannot take the benefit of this provision, that if you've served half your maximum sentence and if you've not your trial is not completed, you are entitled to bail. That the scope of the exclusion has been expanded from just prisoners sentenced to potentially who could be sentenced to death, a death eligible offense, to also offenses where you could potentially be sentenced to life imprisonment. So that is a very significant expansion of the exclusion and therefore narrowing of the bail provision, right? The next issue on bail is that there is a provision which says that if there is a pending enquiry or trial against you, right? If there is a pending enquiry or trial against you, you will not be given bail. Now, it is curiously worded, that provision which talks about this exclusion. It says, where an investigation, enquiry, or trial in more than one offense or in multiple cases. So it is entirely possible that within one case I could have multiple offenses, right? I mean, one action could lead to multiple offenses. So it's not just if you're saying you have more than one case. It is saying even if there are multiple offenses against you, right? You pending against such a person, he shall not be released on bail by the court. This is a staggering provision, right? And the manner in which it will restrict already the problematic law and practice of bail is mind-boggling in terms of the impact this will have on the ground, right? And this also, the way this is worded, this also excludes you from getting the benefit of the previous provision that I was talking about, that if you've served half your maximum sentence and your trial has not been concluded, you're automatically entitled to bail. This provision on saying if you have a pending enquiry or trial excludes the application of that provision as well. Okay. So now on police, you have very foundational, in that sense, civil liberty protections being constricted by these new laws, both on police custody and on bail. I want to go to a third aspect and spend some time on something that is a big focus of the laws, of the new laws, and also a big focus of the government, and see what it does. And this is on forensic evidence, right? A big change is being sought to be brought in through clause 176(3), where they're saying that for all offenses which could potentially carry a punishment of 7 years or more, necessarily forensic evidence shall be collected, and it gives 5 years to the states to implement this provision, right? This has to be mapped against the massive investment that the government of India is doing in the National Forensic Science Universities all across the country. The number of campuses that are being opened, right? The number of the massive way in which students are being taken on board, the recruitment in these universities, both of these have to be mapped together, that there is a push for scientific investigations. And I want to sort of spend some time problematizing the manner in which scientific investigations are being constructed in the new laws. What do I mean by that, right? Even under our current law, experts of certain kinds, certain government experts are exempted. You don't need to necessarily call them to court for the reports they have given. The new laws expand this universe of government scientific experts who are exempt from being called to court, right? And of course, the judge has a discretion, but the general exemption is broadened. Second, already has been alluded to by Professor Gopal, the kind of samples that can be collected from you and from whom it can be collected are both expanded under the new laws, right? Now, from signatures and handwriting under the existing law, this has been expanded to fingerprints and voice samples that can be collected, not just from persons who were arrested in connection with the offense, either currently in custody or previously arrested. It expands it to anybody that the magistrate wants in terms of, and only the reasons have to be recorded. Doesn't say for what reasons, it can be expanded, right? Now, perhaps the most crucial exemption and the expansion of this problem is in clause 330 of the BNSS, right? And right, where it says that if you want, there is a proviso to 330 that says that if you, okay, let me just try and explain this before I, if you're talking of documents, right, you have to challenge the genuineness of the document initially if you want that to be examined by the court. One party has to challenge the genuineness of the document. So this is on documents. But what the amendment does or the change does is include a new proviso which also extends this to expert opinion, right? So what it means is that unless a party challenges the genuineness of the expert opinion, that expert cannot be called, right? So no longer is it open to the court to call an expert witness and examine whether the report of that or the opinion of that expert is genuine or not, unless it is challenged by one of the parties. Now you need to map on this provision into the reality of criminal justice system in our country as to who is bearing the brunt of criminal prosecution and who is in prison, who are bearing the brunt of these trials. It is the poor, and it is obviously connected to severe questions of the quality of legal aid. So here you have a provision where the judge cannot examine the genuineness. You cannot examine the genuineness of the expert evidence that is being given unless one of the parties challenges it. And again here, what can be challenged is only the genuineness of the report. You cannot challenge So what you can challenge is only the genuineness of the report, not that the science is invalid, right? Now how valid is bite mark evidence as science, or how valid is sort of footprint evidence, or how valid is blood splatter evidence, right? All of those things. So you are seeing an expansion of the use of forensic evidence and a constriction of judicial scrutiny of forensic evidence. On the one hand, you're saying let's collect more and more and more and let's rely on forensic evidence. At the same time, the legal amendments and the changes are to reduce the scope of judicial scrutiny of forensic evidence, right? I can see that my time is running out, and I just want, on the UAPA point, on the definition of terrorism, I just want to add one small point to the points that Professor Gopal and Ms. Grover have made. The difference nonetheless continues to persist in terms of who will investigate this charge. Under the UAPA, for whatever it's worth, and we all know that's not some great protection, for whatever is worth, it is investigated by an SP or above. But now by bringing in this definition or the same definition into the BNS, the investigation can be into a terrorist offense is by any SHO as well, right? So it can be at the local police station level as well, that terrorist offenses then start to get investigated, and even the bare minimum fig leaf protections in the UAPA are taken away, right? In that sense, as to in terms of who is investigating this case, right? I want to make three broader points very quickly and stop with that. Going back to the point that Professor Gopal said on the intersection between criminal law and constitutional law, I think the weakness of this intersection is going to come to haunt us, right? In the sense that if you see how strong is constitutional reflection and constitutional jurisprudence on criminal law, it is rather weak. On issues of what can we criminalize, what is constitutionally, is there any discourse on what should we criminalize and what can't we criminalize? On the issue of what is a proportionate punishment for certain offenses, right? We've seen there's been discussion on the range of punishments, on the quantum of punishments, on what is known as the proportionality of punishment, right? How much punishment can the law prescribe for certain offenses? Secondly, on vagueness, and we are seeing this issue run across legislations, be it the UAPA or the PMLA or even many of the IPC provisions. The constitutional problem of vagueness in criminal laws again remains underdeveloped. I think we should reflect, and I think, and I will not have the time to do that. Why is there this language of overhaul when we know that effectively there is no overhaul? What is the political significance of this vocabulary of overhaul when in effect about 80 to 85% of the text is exactly the same in these three laws as it currently exists? There is a reordering, and the remaining 15% is very, very problematic mostly, right? So in that sense, why this language of overhaul? And I think it might be useful for all of us to reflect on what is being attempted there. Lastly, on colonial laws, I would just leave you with the thought of what made the IPC colonial, or what makes the Indian Evidence Act colonial? Is it merely the fact that it was drafted by Macaulay or James Fitzjames Stevens, and it was drafted in and brought into force during the colonial rule? Is that sufficient to deem something colonial? Or is it a deeper relationship between the state and the citizenry and its people, and the manner in which that relationship is negotiated through criminal law, that makes a law colonial? That it is not just the factum of time that makes something colonial or not. It is a nature and a certain type of relationship between the government and its people that makes something colonial. I'll stop there. Thank you so much.
Thank you very much, Anup. And I think the manner in which the laws are drafted, if our two esteemed panelists have differing views on it, it certainly worries me, because I think as it is, the manner in which laws are being interpreted. And Anup, you talked about how the bail provision has been massively shrunk, and I think the recent ruling where it was said that jail and not bail is the norm, and that's still sort of bothering many of us. And in that context, hearing what you said on the bail provisions is certainly very, very worrying. And one of the things which, like you said, 85% remains the same, 15% has been changed, and it has been changed to in the name of decolonization, and to say that we want to move away from the colonial nature of these laws. But like you said, it's really how the relationship is negotiated between the state and citizens. And from what we are hearing from all our panelists, it's very, very concerning and worrying the aspects that have come to light so far. Now let's see what Sarim has to say to us. We have Sarim Naved. He's a criminal lawyer, very, very fine criminal lawyer who stands with all those who are incarcerated, who are sort of hounded, who have been hounded by the state for dissenting, for speaking their mind, and has been sort of, fighting those battles in courts for us. So, Sarim, I request you to please come and share your thoughts with us in the next 12 minutes. Thank you.
Thank you so much, Anjali, for the introduction. I'd like to clarify that most of my clients are out of jail. You said they were incarcerated. I thought it important to mention that. Thank you, sir, also, Mr. Bhushan, for inviting me here. So I am not going to go into a section-by-section discussion of these laws, because, much smarter people than me have already done that. But I was reading these laws yesterday and today. I read them earlier, but not with any great level of detail. It's the collegiate kind of way in which these have been drafted which really gets to me. Anup had mentioned about the forensic examination part. They say that offenses punishable by more than 7 years, there have to be forensic examination. Why not the offenses punishable by less? The idea is to get to the truth, not to have a gradation saying that offenses which are, not punishable by more than 7 years, we don't really care about them. The other part is, what happens if the forensic examination is not done? Does the investigation go completely out? So everybody goes scot-free? What are the implications? I find in this draft is the implications which have been left completely out of consideration. The debate that we have seen about bail, I tend to stand with Ms. Grover in her interpretation that it says 90 days, but 15 days can be split, because there's also another section 480 where they have said that just because you haven't taken police custody in the first 15 days doesn't mean the police can say that don't give bail, just because we might need custody later. So I think that interpretation I would go with. But the fact is that at this stage, when these laws have been here for 2 or 3 months by now, not notified of course, if we are debating on what the bail provisions are, we are not in a very happy position. Say, as a practicing lawyer, the first stage where a client, where an accused approaches you saying that something has happened, I've received a summons or there's an FIR, what do you do? The first thing you consider about is, am I going to go to jail or not? Now, with this law, the answer will have to be, okay, let me open the book and let me think about it for a couple of minutes. Let me call a couple of people. Let me have a discussion. There is going to be such chaos. There's going to be such chaos when these laws are notified, because, in law school, and Dr. Mohan Gopal wouldn't remember me, he was my director at National Law School when I joined, and some people in National Law School, not me obviously, used to plagiarize. Never me. So what people used to do was, they would take something from somewhere and paragraph 1 would become 5, 10 would become 2. That, whatever software you're using, whatever method you're using, don't get caught out. This feels to me like that. Somebody was given a project to do and they didn't really put their heart into it. They had some perhaps good intentions. And they said, okay, let me section 239 can become 482, section 4 can become 28. Now that has left us nowhere. I can imagine 1st July, if these laws come into operation, we'll all be standing in court. The judge will be looking at me, I'll be looking at the judge saying that what has changed. Let's all look at the law. Everybody will be confused and they'll say, okay, put it up in September or October and then we'll discuss. Then that's, at least in one court. There'll be people in every part of the country where this will be happening. One high court will have its own interpretation, another its own interpretation. Something will come to the Supreme Court. Somebody will challenge it and say, no, I'm withdrawing for ABC reasons. We're going looking at 3 to 4 years of utter chaos. And my suspicion, although of course Modi ji is a great man, is that this is aimed at scuttling the system as it stands today. Why not, if your intentions are pure, why not bring it into operation right now before the elections? Because there'll be chaos. You want that after the elections when nothing can be done about anything, and then there'll be utter chaos, and you say that these systems are never going to work. These are colonial systems. These are Macaulay-based systems. Now perhaps the new actual draft will come after that to rescue us from the chaos. Because in this law, in one way I can say that nothing much has changed. 90% of the laws are where they are, especially the Evidence Act. Evidence Act is, I think, 99% what it used to be, apart from, they've changed the section numbers and headings. But one thing they brought in secondary evidence is that if there is a document which relies on other documents, a person who is an expert at examining that document or other documents can give evidence about it. I don't know what that means. It could be very narrow, it could be very wide. Perhaps you're going to say that no need to bring in evidence about whatever document, whatever proof. We have an expert. We have a CBI officer who will perhaps look at one document and say that, oh, not only this, but this means that A, B, C, D things behind it must have happened. We don't know because it's just been brought in. IPC, of course, much has been said about the terrorism and the organized crime sections. It's completely bizarre. I don't know of anything in the history of this country where the police had a choice. Not only that, that part of this offense happens under the general law and part of the special law. They'll have a choice of whether I prosecute this guy under the IPC or under the NSBNS or the UAPA. Why should you have the choice? Why should I not know what I'll be prosecuted under? The rule of law is that a special law always will have precedence over general law. That being the case, then why is it being drafted like this? There's a provision saying that the provision of in-camera trials will be extended to POXO cases. POXO already has a provision saying that trials will be in camera. So is this carelessness? If it's carelessness, it's beyond shoddy. Otherwise, it just gives rise to a lot of doubts in one's mind about the intention behind this particular law. If we just go through the criminal procedure code, or what it's called now, the Nagrik Suraksha Sanhita, there is a wonderful provision that I found, which I really like, is that an accused is given a charge sheet after they are produced. And they say in this that it should be given within 14 days. Right now there's no time limit. It's a very good provision. They also say that a victim, in brackets, if represented by an advocate, will also be given a copy of the charge sheet. So if you're not represented by an advocate, please get one. Then bringing community service, again not defined. What is community service? At least define it. There's a section that says that every state government must bring in a witness protection scheme, full stop. What will be the contours of that scheme? Who is going to fund it? Will every state have a different one? This is utter laziness. I'm given a job, and let it be. That guy, I'll tell him to do it. You can do it perhaps in government at a certain level, but not in lawmaking. You can't delegate an entire power to the different state governments to do whatever they will. Otherwise, why include it? They can do it in their own sweet time. Then there are some other things. There's a section. I'll confirm what section number is, but I find that to be utterly terrifying. It says that contempt of a lawful order by a public servant, that person can remove you, put you in jail for 24 hours, produce you before a magistrate, and there's no contours to it. A policeman could be standing here and say, you don't stand here, you go stand there. If I say no, technically I'm in jail. It's not linked to any offense, it's not linked to any act. Absolutely bizarre.
It's not all public servants.
Police officers, yes. The best of the public servants. There are some, this focus on audio video evidence that has come into it. That's an interesting thought because post-COVID we have all been struggling with it. Those of you who are aware of how Delhi courts are functioning at least, is that almost everything we have the option of doing it online, including evidence provided that the accused agrees. So we had an experiment here with the Negotiable Instruments Act check bouncing cases, one of the simplest category of criminal cases, where they said that, look, everything will be online, complainant does not need to come, accused does not need to come, witnesses don't need to come. What's happening now is that the judge sits in his room and the witness will come to a room next to that room and he'll do video conferencing from there. So what's the point? Because in this law also they say, and I understand why they've said that you can give evidence from a spot which the state government will allocate. That this is the spot from which you can do audio video evidence. But why not just go to court then? I can understand there may be certain very limited circumstances in which you'd say that, that the witness will be intimidated, the witness will be, the mental pressure will be too much. But why bring in these bizarre rules where clearly the discussion that has happened over a cup of tea? There's no depth to it. There are no solutions in this. If you said that, look, these are very horrible laws, change them. Don't retain 90% of them. But what they've done is they've retained 90%, they've made it more confusing, and they brought in things without thinking of the necessary implications. If a case starts and the forensic examination is not done, do I get out of it? I would say yes. If a case happens and, audio video evidence, they say, apart from that, they say that no more than 2 adjournments to be given. I specifically said that counsel being engaged in another court is no grounds for an adjournment. Now, in a city like Delhi, if I have a case in the Supreme Court, I'm supposed to leave that and go to the trial court. I understand what they mean, but to bring such pedestrian factors into the law shows, number one, mistrust of the judiciary, mistrust of everybody participating, and more than mistrust, perhaps it shows the contempt they have for everybody. In लोगों से नहीं हो पाएगा. They have to be told very simple things. As a matter of fact, day-to-day trials have been part of our system here, CRPC forever. They're part of the NIA Act forever. Every UAPA case has to happen day-to-day. We have gone and taken orders, and what happens is, it never happens. Why? Build up capacities. Train the people. Even in this, all these wonderful things about every search and seizure should be video recorded. I like it. I think it should be video recorded. But I know what's going to happen, that nothing will be filed in court. Videos will be they'll be corrupted. Something will be blocked by a hand. And there'll be no consequences to anything. If you talk about the colonial aspect of these laws, the biggest colonial aspect was that there is no consequence to the state officer, to the police officer, when they violate my rights. And that has continued. They have brought in a section which says that the magistrate can take cognizance of an offense done by an official in discharge of the official duties, but only if that person's superior is the complainant. If you're going to give this magistrate the power, at least let me go and tell him. But no, you can't do it. Only that person's superior will. What is the purpose behind any of it? Perhaps a parliamentary debate would have informed us. But considering that there was none, we are completely in the dark. There are other things about, audio video evidence, about how to record it, about summons to be sent through electronic means, which again at first blush sounds so attractive, right? We waste so much time that, in the wonderful language of Delhi courts, Tamil hua ke nahi hua. Sir, wo report to aa gayi hai, but Tamil nahi hua. Okay, next date. But what do you mean by electronic means? Perhaps you'll serve me on my phone number, which is 5 years out of date. Perhaps you'll make a new address for me, thinking sarindavid@yahoo.com. I never use it. You'll say, tell the judge, look, I gave it to this guy's name, and he's been served. What happens then? You also have a provision now for trial in absentia. If I'm not served, it's so easy. It's so easy to kind of have me put me in that stream where I have no remedies. I'll perhaps find out after I've been convicted. And in absentia, there's also a bizarre provision that says that they will get you a lawyer in case you are already not represented by an advocate. So that's a very nice thing. I can just abscond and the lawyer can do the entire case. If I get convicted, I stay out. If I get acquitted, I come in. So where is the thought process behind this? All these things are very nice that we have said that judgments to be given in 45 days. All right, no problem with that. There's a provision that says that you have to file a discharge application for the uninitiated discharge is when you say at the initial stage that I should not be put to trial. Was always there, but now they have said you have to do it within 60 days. So if I do it on the 61st day, what happens? Do I give up my right to plead not guilty? Where is the thought process behind this? Where is anything new? Where is anything constructive in all this? I have a very uncomfortable feeling that this particular set of laws has been brought in very deliberately, knowing the chaos it will cause, knowing that our systems already teetering under so much pressure are perhaps not going to respond to this chaos. And then you say that, look, these systems were never meant for you, they were never meant to be successful, something inherently wrong with it, Nehru brought them in. And then we'll be left with something particularly horrible, and we will have nothing to, and the people will think that, okay, whatever happens, it's better than the old system. So that's why I think I read this on livelaw only today, that I think somebody had challenged these laws and that's been dismissed on the grounds of locus or that's not notified.
Not enforced yet.
Not enforced yet, but we have all challenged laws before enforcement earlier, and that has been heard. If this is not something that deserves the attention of the Supreme Court, I don't know what is. Are we waiting for the 1st of July? Are we waiting for people to go there and they'll have 8 different judgments from 8 different high courts? Somebody saying police custody can be 45 days. Somebody saying only the first 15 days. Somebody saying you can have 15 days but to 90 days within 90 days. Because you're going to have the situation. And that's, I think, the real danger of these laws. I don't know what the solution is right now, apart from opposing the judiciary and or perhaps hoping that post-elections somebody will be more amenable or will act in a more responsible manner than has already been done. Thank you all.
Thank you, Sarim. I think the scenario you painted is one of chaos, of disruption, and given that these laws really impact each and every one of us, I think this is really very, very troubling to hear. And like you said, the kinds of provisions which have been brought in and the fact that the Supreme Court today has dismissed the matter, I guess then what we are really looking at is that these laws, if they come into effect on the 1st of July, we'll just have to wait and see how it unfolds and how it really affects all of us. I'm going to request now Justice Madan Lokur, who's joined us. Welcome, Justice Lokur. He is the former judge of the Supreme Court of India, has served as the Chief Justice of Andhra Pradesh and Guwahati High Courts. He's currently also the judge of the Supreme Court of Fiji. And however, how we think of and know of Justice Lokur is someone who stands for all our civil liberties and is a very, very vocal supporter of people's fundamental rights and civil liberties. So thank you very much for joining us today, Justice Lokur.
Thank you, Anjali. There are 2 things that I would like to say before I speak further. One is my apologies for coming late. Right, I was tied up with something, so sorry for that. The second is that I've not had the benefit of listening to Professor Mohan Gopal or to Vrinda. I've also not studied the laws section by section to try and figure out what they actually say. So I will not be able to criticize any particular section because I've not read it. Okay, that's how I function. But please keep that in mind. The general comments that I would like to make really are that, when we are looking at the criminal justice system, we are looking at 5 players in the system. One is the accused, one is the prosecution. These are the 2 principal players. You also have the witness, who is also, I believe, extremely important. You have the victim, of a crime, and you have society, all of us. Now, the purpose of the legislation, at least from what has come out in the newspapers and from the statements that have been made by persons in authority, is that the present criminal justice system is in a pretty bad shape. It takes years and years for cases to get decided, which is a fact. So really we want to expedite the disposal of cases, and that is why it is necessary to have a new legislation. Colonialism is also one of the aspects, because the system was such that it gave rise to delays. So if you look at it from that point of view, I think it is important that society gets involved, because society is the one that is actually the one that has an interest in cases being decided quickly. If there's a person who's committed a series of murders or committed a series of other crimes, it's best that he get convicted quickly, and that's good for society rather than have to wait for about 10-15 years. And that we can do it has already been shown. For example, the attack on Parliament, that was decided by the trial court in less than a year. It was decided by the High Court in, I think, just about a year, and by the Supreme Court also in just about a year. So in about 2 or 3 years, the Parliament attack case, which was very important, was decided. We've had the Nirbhay case, which has been decided. So if expeditious trial is possible, it can be done. So really, I don't see the reason for bringing about these changes. Now, you look at it from the point of view of an accused person. What is his interest in the law, whether it's the old act or whether it's a new penal code? One is that the investigation should be completed quickly. The underlying premise of producing a person before court within 24 hours is that the investigation should be completed within 24 hours. If it is not completed within 24 hours, then you ask the magistrate for a remand, and you justify the remand that I have good reason to believe that this person has committed the offense, and I need to further investigate for A, B, C, D reason. And there are certain parameters which have been laid down by the Supreme Court, namely that this person may have an impact on the further investigations by influencing the witnesses or destroying the evidence and so on. So therefore, he should be kept in custody, police custody or judicial custody. Now, some of the provisions which deal with investigation, they do not seem to keep that in mind, that you have to try and complete the investigation within 24 hours. In fact, the provisions seem to suggest that the investigation can go on, for a considerable period of time. The accused person can be remanded to police custody at any point of time. That is not conducive. Basis for this, as far as the accused person is concerned, does not exist. Changing the law regarding investigations. The accused person is also interested in having the charge sheet filed against him quickly. If he is guilty, or if the prosecution believes he is guilty and he has committed the offense, file the charge sheet, prove the case. If he is not guilty or you don't have evidence, why keep him in custody? Why, keep that sword hanging over him that, listen, we are going to file the charge sheet at any point of time. Now what is happening is that this system of supplementary charge sheets has become more or less the rule. So you file some kind of a charge sheet, and then you say, well, further investigations are required, we'll file a supplementary charge sheet, there are so many accused persons, and it just goes on and on. Now this keeps two things. One is, it keeps the accused person under a threat, number one. Number two, it gives the police reason, or gives the prosecution reason to keep that person in custody, saying that investigations are still going on and we need to keep that person in custody so that we can file a complete charge sheet. What has also been happening is that the provision of default bail has got completely diluted by a recent judgment of the Supreme Court. So even though the investigation is not complete, the charge sheet has not been filed, a person is entitled to statutory bail under the existing law after 60 days, and in some cases after 90 days. That provision has been given a go-by by the judgment of the Supreme Court. And really that makes it that much worse for an accused person. I don't know to what extent the new code changes that position. I don't think it changes that position dramatically. In any case, if there's a judgment of the Supreme Court, there's very little that a magistrate can do about it. The other thing that an accused person would be interested in is the grant of bail. All right. Now, the bail jurisprudence has been crystallized by judgments of the Supreme Court, any number of judgments, and by any number of judgments of all the high courts across the country. Where was the need to change that? And by changing it, the bail jurisprudence has not been liberalized. In fact, it has been made even more stringent. So really, as far as the accused is concerned, he's in trouble. Earlier, if he would have got bail, the fact that the courts are not giving bail is another matter altogether. But if he would have got bail under the existing bail jurisprudence, perhaps he will not be able to get bail under the new law. So again, it is functioning to the law is functioning to the detriment of the accused in matters of bail, which means a loss of personal liberty. The third thing that an accused person is interested in is the trial. Now, I'm not sure whether there are any provisions over here for expediting the trial other than saying that, listen, don't grant adjournments for the asking. Okay, it's good enough to say that. Under the Civil Procedure Code, there is a provision that has been brought about by an amendment to say that not more than 3 adjournments. I don't think that has ever been implemented. I mean, you go to a civil court, you can get an adjournment for the asking, right? So even if there is a provision, which I believe there is, that you can't have more than 2 adjournments or something, it's not going to work. So really, what is it that has been done to expedite the trial? It's nice to say that, okay, you bring in electronic evidence, videography, this, that, and the other, but there are complications in that as well, Today we have all kinds of videos going around through artificial intelligence, morphing of images and all that. Now, supposing somebody says that, listen, you've taken this statement, but that's not my face, that's somebody else. What do? Are you going to send it to some forensic laboratory? And if you're going to do that, how is it going to expedite the trial? So really, I think as far as the accused is concerned, as far as the courts are concerned, in terms of the liberty of the accused person, in terms of the trial, the very purpose of bringing about the new code, I don't think has succeeded. On the contrary, I think it has got defeated by some of these provisions. Then the second important player in all this is the witness. Now, there is no provision for witness protection, although we've been talking about witness protection for a long time. This was the opportunity to provide for witness protection. It's not been done. Today, you would have read in the newspapers about a person who has a rape victim, right? She's probably got beaten up or something. Something has happened to her. What kind of protection does she have? We've had instances of the parents of a rape victim being threatened. What kind of witness protection do we have? Has the new code provided for that? Now you have witnesses coming to the courts 10 times, 5 times, to be told that case can't be taken up today, come on some other date. And this sort of a thing is going to continue. I mean, chaos is one thing, but the load on the courts is going to increase because of interpretation of various provisions. And if that load increases, as it is, the courts are overburdened. And if you're going to ask them to keep interpreting each section, those 15% new sections or 10% new sections, it's going to take time. And then you're going to have different interpretations, and then again, there'll be an appeal to the High Court or a revision to the High Court, and the matter gets delayed. So really, from the point of view of the judiciary, from the point of view of the witness, I don't think any dramatic purpose is going to be served. You have the prosecution. Okay, that's an important player, and by and large, I think the provisions of the law are more in favor of the prosecution. I'm not particularly worried about them. They can look after themselves, and they have been looking after themselves. So really, I don't want to say anything about the prosecution. The victim, okay, there have been some amendments in the law that were brought about giving certain rights to the victims. I'm not sure whether those rights have been increased or whether they have been retained. They're the same. Okay, they appear to be the same. So again, what is the dramatic change that you brought about? Victims are the ones, like I mentioned today in the newspapers, you have this victim who's been, beaten up or something. You had the victim in Hathras. You know what happened to her? What are you doing for the victims? What are you doing for the witnesses? If you have to bring about a change, these are areas, which concern us as society. That why should a victim have to go through this? Why should the family of the victim have to go through this? So instead of looking after the interests of the accused person, which I think is a constitutional right, instead of looking after the interests of witnesses who have got nothing to do with the crime. I mean, there's a murder committed somewhere and I just happen to be there. I mean, what do I have to do? I've got nothing to do with that crime. I'm neither the victim nor am I the perpetrator, but I just happen to be there. And if I'm told to come to court every now and then told to go back because there's no time left, it's sheer harassment for the witness. No change as far as the victim is concerned. Why bring in the new law? In fact, I would think that they should have strengthened the rights of victims if they had to do justice to the victim by giving the right of representation, by enabling the victim to say what he or she wants to say in the court and file an appeal and so on and take the matter to the logical end. All this, I think, has been given a go by. So really the purpose of bringing about this legislation, the penal code or the new penal code, really to expedite trials, I don't think it has served the purpose. It has been detrimental to certain people, which I have identified as the accused and the witness and the victim. How does it benefit society? If the trial is not going to be expedited, if there are no provisions for expediting a trial or ensuring that a trial is expedited, I don't think society is going to serve any, society is going to benefit at all. So overall, I think apart from chaos which has been mentioned, I think what is going to happen is that there is going to be an increase in litigation. There is going to be differences in interpretation, not only within a court, but within different courts. The matters will then go up to the Supreme Court, and the Supreme Court will also get clogged. I just want to mention one thing, there was a system that had been introduced at one point of time of fast-track courts in criminal cases, and a direction was given, that every court must decide something like 14 murder cases in a month, which is a fantastic number. That means in 2 days you're supposed to decide, go through the arguments and all that and decide these cases. Many judges, particularly in UP, managed to do that. All right? And the consequence was that the number of appeals went up in the Allahabad High Court. At one point of time, 400 appeals were filed. They didn't have the judges for that. And Allahabad High Court is still reeling from that direction that was given. It's the same thing that's going to happen. You're going to have cases coming up to the high courts, and then from the high courts going to the Supreme Court, clog the system and defeat the very purpose of the so-called purpose of the laws. Thank you. That's all that I have to say. Thank you.
Thank you, Justice Lokur. And I think in all the points that you made, the underlying question that I could decipher was that of intention. and what is the motivation behind bringing in these changes. And unfortunately, given the nature of lawmaking in the country now, where we know 142 parliamentarians were suspended and these laws were rushed through parliament without any discussion, we are going to be in the dark, but we are still going to have to live with the consequences of these laws coming in. I'm going to open the floor for just taking 3 questions because we don't have time, and then in 1 or 2 minutes, if the panelists all want to give their concluding thoughts or responses. Yes. Yeah, you can just turn on your mic there and.
Good evening to everyone. Myself Rahul Magan. So this is Supreme. My question will be very straightforward, less than a minute. This is Supreme Court Rules 2013, latest edition, page number 162, judgment number 31, Lalita Kumari State versus UP, which clearly mandates the preliminary inquiry. Now, this book, which I'm also referring, and thanks to the ma'am, this is IPC, section 85, which is nothing but 498A. We all aware that our judicial system is around 5.4 crore cases and growing, and sir rightly pointed out. And majority of the cases filed under 498A read with 406, 407, 408, 503, 504 and 509 is fake and frivolous. Now my question to you is, if I read this, which is 154 Purane wala, CRPC which is 173 Naya wala, here you are giving the power, what the word is used, may. A police officer may, with the prior permission of Deputy Commissioner of Police, to do a preliminary inquiry. Let it be straightforward. Please answer this straightforward question. I just bribed the section house officer not to do the preliminary inquiry, and somebody bribed the section house officer to do the preliminary inquiry. Where is Lalita Kumari State versus UP?
Okay, thanks. Yeah.
Can you hear me?
Otherwise, you can use this. Switch it on.
It's on. Is it on?
Now, can you please switch off that mic?
I have 2 questions, very quick ones to anyone on the panel. Why is the learning or the unlearning of this law any different from any new law that comes out? If it's a brand new law, why is it different? And secondly, when it came to the IPC, it's a 160-year-old law now. There are various judgments that can act as precedents for future cases. So what happens when the new law comes in? What precedent does one rely on? I don't know if I made myself clear, but
Yeah, that's fine. Thank you. Is there any? Yeah, Pamela, please.
Actually, my question is actually addressed to Professor Gopal, in the sense that I wanted to know, because you have talked about how this set of laws are actually a Bharatiya Nyaya, and it's part of that entire effort to bring in Hindutva in another way. And in an earlier lecture, you had talked about how the judiciary itself is undermining the judicial system. So it seems to be almost like a mirror image, the processes that are happening within the criminal justice system. So I wanted your thoughts on that. Thank you.
Thank you. I'm afraid we won't be able to take any more questions. Okay, one last question. No more.
I want to ask 2 things. First, recently we have seen a lot of cases where FIRs have been denied to the accused persons, especially in UAPA cases. So do we have anything on that under the new law? Second, what happens to the pending cases on sedition, like Delhi riots case? A lot of cases are still pending. You have, in many cases, you don't even have charge sheets filed. So is it the case that under the new law it will be treason, or is it the case that it will go into UAPA? I mean, I just want a clarification on that. Yeah.
Thank you. So can we actually just go down the panel and including your concluding thoughts, if you have any, and any questions that you might want to also answer. Sarin, can we start with you, please?
So I'll just answer the last question. So this law says that anything that's ongoing, including any inquiry, will continue under the old law. Of course, there will be overlaps. Somebody perjures themselves during a trial, what procedure will be followed? Something is seized in an ongoing inquiry. So all these questions will have to be answered. But right now, as per this law, anything that has initiated before the 1st of July will continue under the old law. So for a long, long time, we'll have two systems.
No, I just want to leave a concluding thought that this raises a larger question of the imagination of criminal law amidst all of us, right? What do we see the role for criminal law in society as? And it raises those questions. And very often we tend to use criminal law and want to use criminal law to solve all sorts of social problems, which it absolutely cannot, right? And there is also a public validation of more and more and more criminal law and more criminalization, more punishment. And these are some of those, and though some of those dynamics feed into all of this, right? So it might be worth thinking about that.
Thank you, ma'am, for your question. And that's will take more time than Anjali will give me. But I'll still say a minute or two. But before I get there, I do want to say that we know 21 is the basis of part 3. And many jurors have said that you basically, you need just 21 and it captures everything. But it's fleshed out deliberately. And so we can't just say 21. 21 is the light that shines on everything and as basis of liberty. But the particular attack is on 19.1a, 19.1b, 19.1c, because the purpose is to ensure that there is no challenge on behalf of democracy. And it is directed at democratic forces. And therefore, we have to develop much sharper strategies to defend 19.1a, b, and c, including in criminal courts and in constitutional courts and civil courts and in public discourse, and make people aware that this is undermining the very nature of our republic. And the next brief point I want to make is that we should not run into the error of venerating the old IPC and CRPC.
Yes.
It is the unreformed Star Chamber that the British left us. Colonialism is putting in place a brutal system which punishes the poor and protects the rich, because the purpose is to subjugate people and allow an oligarchy to rule. And so colonization is simply happens to be a particular type of oligarchy coming in and going. So I agree with Anup that we should not link it necessarily to the nationality of the oligarchy. We had one oligarchy replaced by another oligarchy, but it's a Star Chamber. And they want to keep the Star Chamber and just send democratic activists into it, build a pipeline, a very fast-moving pipeline of, you speak and Mr. Bhushan is here. He'll go down in the Guinness Book Record of the fastest processed criminal law case in the history of the world, the modern world. He tweeted, and within 1 week or 2 weeks or something, it ended in conviction in the highest court of the country. Right? So they want to fast track any kind of dissent into the Star Chamber, but keep the Star Chamber alive. As I think Justice Lokur, we were in college together. I was 1 year ahead of him in Delhi University Faculty of Law, and I've known and admired him for many, many, many years, half a century now, Madan. Yeah. And, yeah. So, so as I agree with him that there is no intent to reform the Star Chamber. In fact, it's the opposite. They want to keep the Star Chamber so that the disincentive to speak will be even greater. You don't want to reform it. You just want people to throw them there, throw away the keys and let them die. And I had a chance recently to speak to about a couple of hundred prosecutors. I was invited to speak to them, and I tried to tell them that you don't forget you are law graduates. You are the last line of defense. Because nothing can happen without your intervention, more than the defense lawyers. So please defend the Constitution, please defend the Republic as prosecutors. And I think we need to engage with the prosecutor community as lawyers, as legal professionals, as much as we can, and try to strengthen the defenses. I know it won't have much effect, but we still need to do that. I told them we cannot forget that every single person involved in the death of Stan Swamy was a law graduate. when the people who remanded him, the people who refused to give him bail, were all law graduates, and somehow this legal education did not train them to protect liberty in a way that it's like a doctor being trained in the medical college and then and killing people, knowingly killing people, participating in murder. That is what I think that's exactly the equivalent of law graduates participating in sending an 84-year-old priest who has done nothing but fight for the rights of others to his death in jail in the middle of COVID. And so we have failed, as I think, as Anup and I am much more to blame than him. He's young and trying to do a much better job. We failed to instill a conscience in the heart of these law graduates. So we have to appeal to the legal community. And lastly, I want to say on your point, yes, I think there is a group. What is very dangerous now and unprecedented is there is a very large number of people in all parts of the state and outside the state, in the economy, in the media. There is a consensus that a theocratic autocracy is the best way forward for this country, and all this kind of rubbish should be thrown overboard. The job of the judge is very clear: dushta dand, sajana puja, rajya raksha, kosha vriddhi. Dushta dand, right? So you just decide who the dusht is and you administer I had one of these guys sitting next to me when I was coming here back from Bangalore yesterday. He referred to some the same incidents that you're referring to and said these fellows should be taken on the streets and thrashed and killed. That's what they believe. So there is a consensus here amongst this elite, and as human beings, not as judges or lawyers, many law teachers, judges, lawyers believe in this. So they're not defending the liberties that are part of the heart and blood of the republic. So I think we have to, we are fighting a very difficult battle. I've tried to suggest that there are theocratic judgments, judgments that look to religion as the source of norms and of functions, and that number is growing as against constitutionalist judgments which will only look at the constitution for growing. We should be aware of it, we should call them out, we should protest against that publicly, and we should let the public know what's going on. If a doctor is using witchcraft rather than medical science in writing his prescriptions, the medical profession has to tell the public that this is going on. No one else can say that. So the legal profession has to call out theocratic judging and judging that violates the constitution much more openly. I think Anup is one of the rare sitting academics. I don't know how long he'll be sitting, but who's been brave enough to stand up and draw attention to what's going on. But we all have to do that and create awareness. Thank you so much. Thank you for your patience.
Yeah, okay, the only thing that I just want to mention is that if you remember when the issue about the interpretation of sedition came up, the Supreme Court was told by the Solicitor General that the whole thing is being looked at all over again, so therefore adjourn the case. And the Supreme Court adjourned the case. And yeah, they did look at sedition, and look what they've done. Yeah, made it even worse. So really,
calling it sedition plus.
Sedition plus, yeah. So there you are. So really, I'm a little puzzled about the reason for all this. Yeah. That's all. Yeah.
Thank you.
I'll just read out the paragraphs that you mentioned about the Union of India affidavit. It says the Honorable Prime Minister of India has been cognizant of various views expressed on the subject and has also periodically in various forums expressed his clear and unequivocal views in favor of protection of civil liberties, respect for human rights, and giving meaning to the constitutionally cherished freedoms by the people of the country. He has repeatedly said that one of India's strengths is the diverse thought streams that beautifully flourish in our country. This is the affidavit to the Supreme Court, so it's not to be taken lightly. The Honorable Prime Minister believes that at a time when our nation is marking Azadi Ka Amrit Mahotsav, 75 years of independence, since independence, we need to, as a nation, work even harder and shed colonial baggage that has passed its utility, which includes outdated colonial laws and practices, and it goes on and on. So this was the Union of India saying why they're going to be revisiting sedition. I just want to quickly actually just further add to what Sarim said. So you can only be prosecuted for an offense, for what is an offense when it is committed. You cannot have retrospective application of a criminal offense. So no, if you are being prosecuted for sedition for February 2020, you can't be prosecuted under now sedition plus. So that safeguard presently is the way we have always interpreted the law. I don't know in Amritkal if there's something new happening. You'd asked this question, my friend Anant Asthana was here, who very vigorously goes around the country talking about juvenile justice law. It takes a minimum of 5 to 6 years for the police to understand a new legislation. And when you're saying what is new, yes, we all learn new laws. There is something which at least, I'm sure those who deal with law, there is a muscle memory. You say 302. You say 420, this is part of your culture almost. Now there is a completely new thing. Why? Why do I have to undertake this exercise? And I agree with Sarin. This government actually uses chaos, diversion, distraction as a political strategy. This is not just happening by chance to reshuffle. You want to change a few sections. Sections have always been amended. There's nothing unusual about that. Do that. Why do this little jig and say, oh, there's something completely new? It's not. And it was bad earlier, you didn't improve it. That's what happened, you made some things worse. I was hoping one of my panelists will take this question and not put it in the women's quota, but I will address it. And I don't like being the women's quota. I'm going to remove two aspects from your question. It is your opinion that there are many false cases. That's an. So when I'm answering, can I please have the respect? I did not interrupt you at all. Let's at least have a conversation. You can be angry, but we will have to have a conversation. The Supreme Court has wrongly said the Supreme Court is not God. The Supreme Court is fallible, so says the Supreme Court, and I have a Supreme Court judge sitting next to me. The Supreme Court judges, while hearing a bail application, passed a remark, there are many false and frivolous cases. I read the judgment quite a few times. Was there a footnote of a study? I'm sorry, biases prevail everywhere. They are not independent of them. Coming to the legal question, corruption can take place for any provision of law. It has nothing to do with 498 and corruption are not intersecting in the SHO's room specially. So these two I will remove and answer the legal question. Lalita Kumari is the law of the land. And that is why I said this code is in defiance of what is the law of the land. It says preliminary inquiry will be on these. That is the law. The law cannot get overturned by a statutory provision. There will be challenges to it. It has increased the number of preliminary inquiry. The other aspects are your views. People can have different views. A Supreme Court judge can have a view. Until and unless it's substantiated, it's no more than one opinion. So I will leave that at that. I only want to actually draw attention to something very different. I think we need to look at technology very carefully. Technology is now being presented particularly in criminal courts. People are not to be trusted. As I said, this is the shift from the citizen to the suspect. All of us are suspects. We all have to go and prove that we haven't done X. Technology is today being served as what will replace the witness who has always gone and said, rightly or wrongly, that is only so much that cross-examination is going to tell us. Every system has its infirmities, so does the criminal legal system. But to say if technology says so, if forensics says so, if CDR says so, all that is now being brought in to say people are not to be trusted. Technology is to be trusted, and I think that's a very dangerous trend we are seeing, and we need to guard ourselves against that.
Anjali, with your permission, can I just take 30 seconds to note one very telling change? Very small but very telling change, and that is that we had about nearly 30 references to courts, criminal courts in the IPC and the CRPC as courts of justice. One of the changes is the words of justice have been dropped. So they were called courts of justice and now they're called courts. So we know from this that justice is a colonial concept.
Thank you. We always knew that 2 hours will be too short for us to understand and decode these 3 criminal laws that have come, but we couldn't have had a better panel than what we've listened to do that for us. Thank you very, very much for taking out your precious time, joining us today and enlightening us. Thank you. On behalf of CJAR, Common Cause, and of course thanks to Livelaw for covering this and live streaming this event. Thank you.